we refer to model articles. So it means that we adopt the model articles. And then to change the parts we don't want, or to change the part that not really, suitable to your case. But that's very unlikely. Even that's possible, but very unlikely. You try to drop your own, because that's very easy. Number one, you miss something. Right? You miss something. Number two, that may be inconsistent with the company ordinance. So if your own drafted version be inconsistent with the company ordinance, and you know that you will be in trouble, because the company ordinance always, having a high status than your own internal rules. So you create confusions. So normally, I don't suggest, I'm a corporate lawyer, but I don't suggest the client or anyone to drop their own article. Just adopt the model article, and then you change the parts you don't want. Okay? So, model article is something really important. If you are a corporate lawyer, or if you want to focus in corporate law or corporate administrations, so I suggest that you should be familiar with the content of the model article. But that's not required in these modules, right? That's not required. But if you, in real life, you want to focus on corporate matters, I suggest that, right? Just on less than 10 pages. Try to be familiar with all the content. Why so important? Because, right? Because even if you drop your own article, but number one, why so important? Number one, because most people adopt model article. Right? Most people adopt model article. They just change the part they don't want, but which is very rare for the parties to drop everything by their own, which is not advisable. So over 90% of the company incorporated in Hong Kong, so actually based on model article. So that's why you have to be familiar with it, because that will be the version, right, being used by most of the company. And number two, even you are not using the model articles, but remember that if there's something missed in your article, or if there's something wrong in your articles, the court still apply the relevant provisions in the model article in your case. So that's why you have to familiar with the model article. And model article is something important. Okay? Do you remember the question I asked all of you regarding banana and Changong here? What I want to know, what I actually want to know from you guys, because I want you to learn a very important concept. So something we call the object codes. So object code is something really important. What's object codes? When I ask you questions like this, can Changong sell banana? Well, I want to know. So actually it means that I want to ask you questions whether a company will be restricted by something, that there are something that they cannot do. For example, Changong is only a property company. So do you think that a property company can also sell banana, or sell apple, or sell oranges, or sell coffee? So I want you to think about it, whether a company will be restricted by something that they are not capable to sign some kind of contract or to enter into some kind of business transactions. The answer is, of course, it depends, right? It depends on what? It depends on whether you have object codes still. So what's object code? Remember that object codes means the purpose of the establishment of your company. So nowadays, object code is no longer required. It's not compulsory means object code, right? Not compulsory. But in the old days, it was once being compulsory, but not currently, right? Currently, it's not compulsory, but you can still have it. You can still have it if you want to. And for some kind of company, object code is still required. For example, if you are a bank, or if you are offering trust service, like an MPF provider, then object code is still required. It means that the bank can only do the banking business. They cannot sell candy, they cannot sell banana, right? But unless you are, this kind of special company, so otherwise you don't have to, right? Because it's not required, but you can still have it. Because nowadays, object course is no longer it's not compulsory. For all the companies now they are just like a human being. A company can enter into any kinds of contract. What happens if we have object course? Remember, object course being something inside the article. You can only bound the internal parties. So, if we have object course here, and if someone, the directors, if the director try to do something which violated the object course, then what happens? Remember that, right? Remember that. Number one, very important concept. Object course, being a part of the articles, only bound the internal management. So, if the object course state that this company cannot sell banana, and then the shareholders learn about that the directors try to sign some contract in selling banana, then they can apply for a court injunction to stop it, right? Because object course bound internal management, so the internal parties can stop the directors in doing anything violated the object course. But once a third party being involved, for example, the contract already signed, right? Already signed, and then the Apple already delivered. So it means the third party already involved, and that contract is still valid. And you cannot invalidate a contract just because it violated the object course. Why? Because object course, being part of the articles, only bound internal parties, but not external parties. Someone buying apples or banana from the company, that person is an external party, and that person is not part of the company, and shall not be bound by anything in the company. Okay? So once third party being involved, the object course may not work. Remember that. Okay, article is a constitution. By looking at the status, when you think about the status of the article, it is constitutions. But when you think about the nature of the contract, when you think about the nature of article, it is contract, right? Remember, article is a contract. Why is a contract? With the law state that. Section 86 state that the nature of article is a contract between the company and member, and a contract between different members. Very important. Remember that, right? It's a contract. So it means that if anyone is not following the terms in the article, then the other party can sue on it. So the members can sue company can sue members. And we have different cases here regarding the relationship between the members and the company, right? So there are cases. For example, in this case, the article of the company states that the surplus fund shall be distributed by way of dividends. The director instead recommended the issuance of debentures because it is something stated in the article. The article states that the surplus fund shall be distributed by way of dividends. So when the directors are not doing the same, then the company can sue the directors because it is something binding, right? Sue the company, because it is something between the members and the company. It's a contract. You have to do it, which is not just for reference, remember, right? Not just for reference, not just a guidance, but a contract. Everything stated in the article is a contract, is contractual. But you have to remember that articles in the contract, number one, between members and company, right? Members and company. Number two, between members and members, but not between directors and shareholders, and not between directors and the company. So director is not part of the contract here. Very important. Okay? Very important. And one more thing, which is also very important. Whether anything in the articles can be related by the external parties. The answer is absolutely no. Right? No. So think about that. So I'm external parties. I may be potential investors. So this is the company. So this company tried to invite me to subscribe their shares and to become a new shareholder. So in order to have my money, so they talk to me, right? They talk to me. Well, I have some special provision in my article that I guarantee to offer extra dividends to professional, right? It means that if you are a shareholder of this company, and if you are also a professional, like a lawyer or accountant, then I will give you some extra dividends, all right? So that's actually being stated in the article, already written down in the article. But I'm not yet a member. So they show me the article. Oh, yeah, well, actually, right, this is correct. It stated that extra dividends being paid to lawyers, extra dividends being paid to shareholders, being paid to accountants. So that's the reason. I'm relying on it. So I subscribe to shares, right? I subscribe shares. But later on, when I become a member, so I try to ask for the extra dividends. And if the company is not paying me, do you think that I can sue the company? No, the answer is wrong. Oh, come on, I'm a member, right? I'm a member. Yes, I'm a member, subsequently. But you have to think about that when you rely on that article, at the time when you rely on it. Think about the timing. I was not yet a member. And that will be considered by the court, right? That will be considered by the court. Because of this case, take a look at this case. You know, someone being guaranteed to offer a job to work as a permanent legal advisor. So that person joined the company. The company, later on, this person tried to enforce that article, that provision in the article, but the court disagreed with the court. Think about the timing, the requirement, right? Being strictly interpreted. That even their right concerning the member, but it can only be enforced when a person has a status as a member at that correct moment. The timing will also be considered by the court. Something really important, a very important case here. All right? So remember that. Article is something very important. So how many of you still remember the two magic numbers in company law? We have two magic numbers here. Number one is, come on, 51, yes. Another one. Another one. 75, right? So we have two magic numbers here. Number one, why 51? Why not 50? So 51, I can tell you, it relates to auto resolution. When you want to pass auto resolutions, the first hold is 50%. But why 50% is not safe? Why we need to have 51? Why 51 is such a magic number? It's so sensitive. When you think about the law in different countries, in different jurisdictions, so sometimes they have certain kind of restriction that the foreign party cannot own more than 51, right? So 51 is the magic number here. Why? Because when you have 51%, you can always pass order resolution. The first hold of order resolution is only 50%, but having 50% is not safe. Sometimes you can pass a resolution if you only have 50. If another 50% they don't vote, right? They don't vote. They maybe they abstain from voting. Right? It means they are not actually attended the general meeting. So that will be okay. You can pass a resolution with 50, but that's not safe because when you only have 50, you want to vote for yes, another 50 vote for no. Then what happened? Deadlock. All right. So 50% is not safe. So 51% is safe. But when you have 51%, you can always pass a resolution. So one of the very important things that you can do by passing order resolution is to remove director. You can remove director. You control the company. So the first metric number is 51. But we have another metric number, which is 75. Why is so important? Because when you have 75%, you can pass special resolution. When you can pass special resolution, one thing which is so important, you can change article, right? Remember, you can change article, which is very, very important. Why so important? The article is the constitution of the company. When you can change the constitution of the company, then you are almost in control of everything. Think of it, right? The article is the constitution. It governs everything. So if you can change it, then you can change the rules of the game. So you are almost in absolute control of everything. So we need to think about the two matrix number here. Remember, if you want to change articles, you need to pass special resolution, which is 75%, okay? But there are some rules we have to follow. So number one, when you want to change the articles, you cannot change the article in a way that violated the company ordinance. No, right? No, that's not possible. You cannot change the content in a way that which is inconsistent with the company law, which is not allowed. So which is very easy to understand. But more than that, secondly, we have another requirement in common law. When you want to change the article, it must be in good faith for the benefit of the company as a whole. So when you want to change the article, but in a way that, so which may be discriminating to the minority, then we know that something may happen, unfair prejudice application, the minority may sue you. Because when you change the article, you can do so, but you have to do it out for the benefit of the company as a whole. Not for yourself, right? Not just for yourself. So if you try to change the article in a way that only benefits yourself, then that decision may be challenged by the minority in court. Okay? So we can change the article, but remember that there are some requirements that we have to follow. So I think that's all about lecture 5. So let's move to lecture 6. So in lecture 6, we learned about shares capital. So remember that shares capital is something actually is quite simple. So you refer to the ownership of the company. So if there are 100 shares being issued by a company, so it means that the company is being divided into 100 parts. So if you hold 40, then you own 40%. If you hold 60, you own 60%, something like that, right? Not really difficult to understand. So unlike the old days, in the old days, 2014, before 2014, when the company still under the regime of the old company ordinance, it was kept very true. So at that time, we have to think about the authorized share capital. So it means that in the old days, when you think about share capital, how many shares being issued, at what price, you have to think about the authorized share capital. Because at the day, when you incorporate a company, you have to set the boundary, right? You have to set the boundary here. So that will be fixed. For example, if share capital being fixed at $100, so it means that this company can only raise funds by issuing shares, not more than $100. So that will be fixed. But that's not the law nowadays, because under the new law, under the new company ordinance, so nowadays you can issue any shares at any time, at any price you like. We no longer need to be bound by anything like authorized share capital. So it means that you don't have a boundary. If you want to issue shares, and provided someone is willing to subscribe for it, and someone willing to pay for it, then you can just do it, all right? So there won't be any restriction at all. And remember that you have different class of shares, but where are they coming from? So something like owner shares, parent shares, redeemable shares. And there can be A shares and B shares. So there can be many different kinds of shares. But remember that when you check the company ordinance, we don't have exact definitions of the different kinds of shares here. Because the company ordinance only states one thing, that shares in one class with the right being attached to them are being uniform. So it means that the company ordinance only states that when that kind of shares, they're having the same kind of right, that they belong to the same kind of shares. But actually, how you name it is not something stipulated by the company ordinance. So you can state that you can name the shares as A shares, B shares, owner shares, parent shares. So provided that each of them having different kinds of rights, then you have to name them differently. But remember that the share A from this company may not be the same for share A with another company, right? But the law, the company ordinance, is silent regarding how you name the shares. So that's only up to you. The only requirement in company law is that when you have the same right, then it must be the same kind of shares. But actually, how you name it is only up to you. So you cannot compare directly, just relying on the name. For example, owner shares issued by company A, owner shares issued by company B. It doesn't mean that they are exactly the same thing. So I can tell you that normally they are similar. Just like the example I used in the previous lecture. If someone being called as a finance manager, no matter that person working in company A or company B, I guess that they are doing something similar, right? Because we have business practice to follow. But that's not a legal definition. So you can say that the finance manager working in company A and company B must be exactly the same thing, right? No. So that will be the same for shares. Remember that the company ordinance is silent regarding the definition of different kinds of shares. The company ordinance only states that when they have the same right, then they belong to the same class of share, and that's all. So if you want to understand what it means, owner shares issued by company A, what it means, you have to take a look at the article. If you want to understand owner shares issued by company B, the exact definition, then you have to look at the article. Okay? So that's the classification of different class of shares. So one thing we learned in lectures is also very important. Remember that directors control the company directly because they can sign contract on behalf of the company. They can instruct the staff of the company to do everything. All right? So they control the company directly, but not the shareholders. The shareholders only control the company indirectly. Why indirectly? Number one, because there are only something they can make decision on. Only something. Something stated in the article. Something stated in the company ordinance. But not everything. But the directors, they are just in opposite. Unless something being restricted by company ordinance, unless something being restricted by article. Otherwise, director can do everything, right? Which is just the opposite. So shareholders, they can only make decision on something. How they make decision on something? They cannot sign contract on behalf of the company. Even they hold 99%, even they hold 100%. And they cannot instruct any staff to do anything. Because there's only one thing they can do. They can only vote, right? They can only vote. They can only vote in the general meeting. So how the shareholders control the company? They control the company by voting through the different meetings here. So what kind of meeting we have? We only have two kinds of meeting. Number one is the annual general meeting, which is AGM. So another one is the EGM, which is extraordinary general meeting, or just general meeting. So very important. But there are only two kinds of meeting here. Number one, annual general meeting. So you understand from the name here. So annual means every single year. And annual general meeting is compulsory. So it means that there's no choice for the company. You have to hold annual general meeting. And also the agenda being fixed, right? Being fixed. You only discuss director report, financial statement, and auditor report. Fixed. So all this document must be presented in the meeting and for the approval from the shareholders. And then we have the EGM. So EGM, I mean, the definition seems like to be very lazy, right? Because technically speaking, AGM refer to any members meeting. That's not AGM. So if that's not AGM, then it must be EGM. Well, it sounds like to be a lazy definition, but well, I don't agree with it. It's a very good definition because there's only one AGM. We can only have one AGM, and we only have two kinds of meeting. So if it is not AGM, then it must be EGM. Okay? So that's not lazy definition. It's good definition here. So why we hold EGM? One reason. Something that need to be approved by members. Right? Something that need to be approved by members. There's only one reason. But actually, what need to be approved, I don't know. Because there are many different things that require members' approval. So unlike AGM, EGM is not compulsory, and we don't have any specific agenda. In AGM, number one, AGM is compulsory. You have to hold AGM. For AGM, you don't have to. You hold EGM because sometimes you have to. Something that need to be approved by members, so you hold EGM, right? But that's not compulsory. If your company, nothing special happened in your company, then maybe you don't need to have EGM at all throughout the whole year. It's not compulsory, right? So only when something required. For example, if you want to change the name of a company, because the company law state that if you want to change the name of the company, that need to be approved by members, then you hold EGM. Because you need something to be approved by members. Okay? And when someone try to hold the EGM, which is only one thing is certain. Something need to be approved by members. But exactly what is it? I don't know, all right? I have to check the notice. I don't know, because there can be many different reasons. Maybe I want to hold EGM to change the name of the company. Maybe I want to hold the EGM because I want to remove a director. So there are many different reasons. That's one thing is for certain. Something need to be approved by members. But unlike AGM, right? When you hold AGM, I always fully understand that what will be the agenda, what need to be approved, what you want to discuss. I'm absolutely certain, because that is statutory. Okay? So that's the difference between AGM and EGM. I think that's all for lecture 6. Let's move to lecture 7. So in lecture 7, we learned about directors. So remember that something which is very important. Directors is statutory positions, right? Always remember that. Statutory. So when we learn statutory, number one, you need to have directors. You don't have a choice. And number two, the duties and authority of directors actually being stated by the law, and you cannot change. And also remember that sometimes we have to ask the questions. Who is the director? Well, because that's very interesting. So normally, director being someone appointed. But even you are not being appointed, if something happens, then in law, you will also be regarded as a director. Because we have a concept, something we call de facto director or shadow director. So what I mean by de facto director, de facto, I guess this is French, so it means that in fact, right? In fact, you are a director. So if you are always calling yourself as a director, if you are always doing something like a director, then the third party learn about it. Then the law will assume that you are actually a director. So you are actually a director means that anything being liable to the director, then you will be liable. Or any laws being imposed on the director, then you will also be subject to that kind of requirements. Another one we call shadow director. So sometimes we want to know who is actually in control. So someone hiding in a dark shadow to control the other person. Think of the example of Li Ka-shing in Chang'an. So Mr. Lee, right, the senior Mr. Lee, well, he is almost 90, I guess, right? He's almost 90. He resided from the board, and now his son, Victor Lee, is the chairman of Shandong and controlling everything. But so I mean, officially, Lee Ka-shing is no longer holding the position as a director, but so all the directors in the company, I guess, because everyone knows that he's the founder, right? And he's the father of the present chairman. So I'm sure that, so actually all the directors in the company still, take instruction from him. So no one will act against his decisions. So even Lee Ka-shing is not holding the position as a director officially, but he somehow can control all the directors. So probably he will be regarded as a shadow director. So shadow director means that a person who can control the real directors, then that person will be regarded as a shadow director. So if you are a shadow director, then anything liable to a director will also be liable to you, right? Even you never having any official title, okay? So that is de facto and shadow director. So one more thing we have to learn regarding the board of directors. So remember that unless we only have one director, well, that's possible. It's possible because nowadays it's possible to have just one director or one shareholder. It's possible. But if we have more than one director, two directors or more than two directors, remember that they can only make decisions collectively, right? So the company is not being controlled by any one director. The company is being controlled by the board of directors. If we have two or more than two, right? So if we only have one director, of course, that company will be managed by that person only. But if we have two, more than two, 3 or 4, 10, 20, then the company actually being managed by the board of directors as a whole. So they have to vote in making decisions. Now you watch on TV, right? You watch on a movie. But don't mix up with order resolution, special resolution. In the board of directors, the share will not be counted. We only count the hands, remember. So don't mix up, right? Don't mix up. In the board of directors, we only count hands. How many hands saying yes? How many hands saying no? Don't make up with the shares. Shares only be counted in the general meeting, but not in the board of directors. So the company being managed by the board, and they have to vote, and there are formalities, and there are procedures. So I want you to think about if there is something wrong inside the company regarding the procedure. For example, some formalities not being followed in the board of directors, or someone made wrong decisions, not actually following all the stipulation in articles. Do you think that decision still be valid? But I'm not talking about object-course, right? So don't mix up with object-course. Don't mix up with object-course. I'm not talking about object-course. I'm talking about the internal procedures. For example, all right? For example, I want to sell something to this company, but the article of this company say that if this company enters into contract more than $1 million, that must be approved by all the directors with unanimous decisions. But in fact, that contract actually being just approved by the majority of the directors, but not everyone. Okay, so something not actually following the articles. But I'm an external party. If something wrong inside the company, do you think that I will be affected? Yes or no? But don't mix up with article. Don't mix up with articles. I'm not talking about articles. Right? I'm talking about the internal procedures of the company. The answer is no. Because we have something we call a Turkon rule, or indoor management rule. So something very important. It means that if you're the third party and you enter into contract with the company, you can just assume that everything inside the company is all right, right? Even there's something wrong, you can ignore it. That contract is still valid. Because as an external party, you don't have any obligations to understand the internal procedure of the company. So provided that you are dealing with a director, then normally you will be okay, all right? The only exception is actual notice. Any of you remember actual notice? For example, someone send you an email, right, or send you a letter, and informed that if you want to enter into contract, if you want to enter into any contract with this company, you have to understand that this company can only sign contract not more than $1 million. If you want to sign a contract more than $1 million with this company, you have to make sure that this contract being approved by every single director. Okay? What is it? This is actual notice. It means someone actually notify you as a third party. Please beware of something. So that's the only exception. If that happened, if the company already notified you to pay attention to something, then the indoor management rule or the technical rule will not function, right? Will not be applicable, not function, will not be applicable. Okay? So I think that's all about chapter 7. We move into chapter 8. So in chapter 8, we learned something very important regarding minority. Because there are two different rules here. Number one is majority rule, and another one is the compensating rule. Because you think about management of a company being always being managed by majority. Because the majority may be the bad guy. And the minority, based on the mechanism of the company, can never resist or to fight the majority. Another one is the compensating rule. If something wrong to the company, then the company is the one to sue. But what happens if the company is actually being controlled by the bad guys? The minority can do nothing. So we have to rely on the law in order to resolve the problem. So sometimes we have the derived actions. So sometimes we have unfair prejudice applications. But don't mix up the two, right? Don't mix up. Your student always mix up the two. So remember that if something wrong happened to the company, then you can initiate derived actions. If something wrong happened to the members personally, then you initiate unfair prejudice, because they are not the same thing. For example, so if someone stole the money from the company, so it harmed the company. So probably you can think about derived actions. But someone distribute all the profit to themselves, but not to the minority. So that is not something to harm the company, but to harm the minority only. Because the profit will be distributed anyway. Profit belongs to shareholders. So if someone distributes the profit by way of dividends, so that's not anything to harm the company. That only harms the minority. All right? So you have to be very careful. Is there something wrong to the company? Or is something wrong to the members? One more thing. Always remember, when you want to initiate derived actions or unfair prejudice applications, you have to make sure that it's the last resort. Right? It's the last resort. So it means that you don't have other means to resolve your problem. So only if you can prove to the court, then the court will be willing to grant unfair prejudice applications or unfair or the derived actions application. Only when this is the last resort. If there is something you can do to resolve your problem, then the court will not grant any order for unfair prejudice or derived action. Okay? For lecture 8, I don't think anything more we have to discuss. Right? Just make sure you understand the difference between derived actions and unfair prejudice applications. So let's take a look at lecture 9. So in lecture 9, we learn about the financing of a company, right? Financing of a company. So we have two different ways of financing. One is loan financing, and another one is equity financing. So what I mean by loan financing, borrowing money, just like a human being, just like a natural person. When you need money, you borrow money. So you enter into a loan agreement. Normally it's a bank or anyone, right? But loan financing, we have a problem here. When you borrow money, if you have a accounting background, then you understand. When you borrow money, what being reviewed in a financial statement, you become a debt. So when you're heavily in debt, normally, which is not something positive for the image of the company, right? Normally that's no good. So you can borrow money, right? But you have to pay back. So when you borrow money, you are in debt. Not that good. So for the company, for company with shares, we have an alternative way to raise capital, to raise funds. So something we call equity financing. What we mean by equity financing, a company can always issue shares in order to raise funds. Okay? So by issuing shares, when you look at the financial statement, that's not a debt. But the company need not pay back. So when the investor pay for the shares, they subscribe, then the money can be used by the company, right? The company need not pay back to the shareholders. So when you look at the financial statement, that's not a debt. That's only shares capital. So that's good. Normally, right? Normally that's a good thing. But of course, one of the So maybe one of the negative impact, right? One of the other impact is that when you issue shares in order to raise funds, so that may affect the company structures. Because when you are issuing new shares, so it means that there may be new shareholders, number one. Or that's possible that the proportion of ownership of the existing shareholders being changed. Because you are issuing shares to someone else, but not to the others, right? So the structure of the company will be affected. But if you just borrow money from the bank or from the outsider, then the structure of the company will not be affected. But the company is in debt. So you have to balance the two to see which one will be preferred. It depends on what you want. It depends on the situation of the company. So one thing which is very important, when you borrow money, normally from bank or anyone, they don't trust you. So you need to have securities, right? Securities. So in order to make sure that if you are not capable to pay back, then your lender, right? The lender or the bank can have something to do against you. So normally what kind of securities can be offered by the company? Fixed charge and floating charge. Right? Fixed charge and floating charge. So what I mean by fixed charge? What I mean by floating charge? So fixed charge, it means that you created a security over something specific. For example, a car with a car number 123, right? Toyota. So which is a fixed charge? Something specific. I can actually identify what is it. Then we call it fixed charge. But we have another concept. We call it floating charge. Floating. Right? We have floating charge. So it means that, for example, the company, they're having a stock of iPhone. S means my S in plural form, right? It means more than one iPhone. The stock of iPhones here. So when you create floating charge, it means that if the company cannot pay you back the money on time, then you have the right to claim one iPhone out of the whole stock of iPhone, but you don't know which one belongs to you until the day you enforce your foreign charge. Okay? So that's what we call as a foreign charge, something you already learned. So this is foreign charge. And normally, a foreign charge will be preferred by the company, because under foreign charge, the company can still use all the stocks still, right? Without getting approval from the lender, right? But for a fixed charge, if that's a fixed charge, that thing will be fixed, and the company cannot dispose it without the approval from the lender first. So foreign charge is something really important, and you have to understand the concepts here. So foreign charge, it means that you don't really understand which one you belong, which one you refer to. So only at the time when you try to enforce it, then you know which one actually belongs to you. Okay? So we have definition from the court regarding foreign charge, because which is only a charge on the class of asset with the whole stock still, not any particular one. And they are changing from time to time. So you don't know, right? How many stocks here? Sometimes the stock here having 100 iPhones, sometimes 1,000, sometimes 5,000, sometimes just 10. So you don't know, right? You don't know. And the company, they can dispose anything within the class here. But that is not the same for a fixed charge. Because for fixed charge, you know exactly what is it. This thing, right? Fixed charge created over this thing and this thing only. But for foreign charge, floating until the day you try to enforce. Right? So foreign charge is something important. But we also need to learn about the priority of charges. Why so important? So if no one competing for the asset, then we don't have to think about priority. If there's only one charge being created and no one compete with it, fine. No problem of priority. Or if the company is capable to settle all the debt, then we don't have to think about priority at all, because all the debts can be satisfied. The company is still having enough cash to repay all the loans, right? Then we don't have to think about priority. But sometimes we have to think about priority. When the company is not capable to repay the debt, then someone try to exercise their right under the charge. And at the same time, more than one party try to claim for the same thing, then we have to think about priority. So who has the right to get it first, okay? Again, there's something you already learned. So sometimes we have to think about priority. Then normally, when you think about priority, so just common sense. So fixed charge always having priority over foreign charge, right? Something you already learned. You understand the concept because the charge already created on something already. But for foreign charge, you don't understand which one belongs to you. So you are always subject to a fixed charge. So that's the general rule. But we have exception, right? We only have one exception. What's the exceptions? Negative pledge. I hope that you still remember. So something we call it negative pledge. So how to make sure that you are just having a foreign charge, but you still enjoy priority? Number one, if you have a fixed charge, so you don't worry about it, because everyone subsequent to your fixed charge, right? Anything, this one will be subject to your fixed charge, right? But the problem is that if you have a foreign charge here, you only have a foreign charge here, it's only floating. So how can you make sure that this one created on 1st of March, this one created on 10th of March? Because you know that, based on general rule, if you only have foreign charge, even you created your foreign charge earlier than the fixed charge here, but you're still subject to the fixed charge. So because that's a general rule, fixed charge always having priority over floating charge, regardless of the day. So I want to ask you one question. Is it possible, if I'm only holding floating charge rate, that I can still enjoy priority over the subsequent fixed charge? Is it possible? The answer is yes. Because there's something we can do, something we call negative pledge. So it means that when you create the instrument here, when you create a floating charge, you must have some document. Then you have to add a provision as a negative pledge. Negative pledge means that the company promised no charge will be created after this floating charge. Okay? So it means that any charge being created will be invalid because the company already promised that. So this is the final, right? No subsequent charges will be created. So that's the only way that you can have priority over subsequent fixed charge, by having negative pledge. But you have to make sure that one thing, you have to make sure that everyone learn about a negative pledge here. Right? You have to make sure that everyone learn about the negative pledge. So how to do it? Take a look at the election notes here. Because you have to, when you do the registrations, right? When you do the registrations, you have to submit something we call a certified copy of the instrument. So when you do the registration of the charges, not just the form, but you have to certify that loan document. Certify, right? Not just a copy, but certified copy. Certified by solicitors, directors, or CPA, and then you scan the copy and then submit to the company registry. So that will become something public. Then everyone can learn about it. So if you have done something like that, the law assumes that everyone learn about your negative pledge. And then you always enjoy priority over subsequent fixed charge. All right? So negative pledge is something important. I hope that you still understand. But you already learned it, right? You already learned it in the previous lecture. I just try to refresh your memories. Okay, I think that's all for lecture 9. We move to last lectures before we end the revision counseling. So in lecture time, we learn about winding off. So of course, we have to learn about winding off. So in lecture 3, the first thing we learn about company. So that is incorporation. So incorporation is something like the birth of a company, the born of a company. So we first learn about the birth of a company. Then of course at the end, we learn about the death of a company. So what we mean by winding off? It means that we learn how to kill a company. We learn how to terminate a company. So which is, of course, important, right? So how to do it? So remember that, number one, remember that what we mean by winding off? Winding off means that you appoint a liquidator. So a liquidator to take control of the company, sell all the assets in order to have the cash to satisfy all the debt. So that is liquidation. And that's what needs to be done by liquidator. So liquidations or winding off is all about this person, liquidator. There are different modes of winding off. So voluntary winding off, compulsory winding. Compulsory winding off actually means a court proceeding. Do you remember that I told you in the previous lecture? It's not a good name. Compulsory winding is not a good name because compulsory winding off actually means it's court proceeding. You try to wind up a company under a court order, right? So when you try to wind up a company under compulsory winding off, under court order, it means that the court appoint the liquidator. Liquidation, winding off is all about liquidator, right? All about liquidator. For voluntary winding off, it means that you are not relying on the court. You try to rely on your own mechanism to wipe the company. So that can be initiated, for example, by members. That can be initiated by directors, right? So it means that under voluntary winding up, the liquidator being appointed by the members or the directors, but not the court. So that's the major difference, right? That's the major difference. Number one, voluntary winding up means that you rely on the company's own mechanism. And compulsory winding up, it means that you rely on the court action. The court is, take charge of everything. But for voluntary winding up, everything somehow still under the control of the members and the directors. Okay, but where is this come from? Why we have creditors voluntary winding up? Something quite special. Because normally, creditors, as I told you, voluntary winding up means the directors or the shareholders try to use the company's own mechanism to wind the company. But you think about creditors. Creditors, they are not part of the company. They are outside the company. So why they are here? Why they are here? I asked you that question before, right? Which is something very interesting. So I can tell you that actually, there's no such thing as creditor voluntary winding up. No. For voluntary winding up, it means that which is something internal. Only directors and shareholders can initiate voluntary winding up. No such thing as creditor voluntary winding up. But why we have the name here? Well, there's only one thing. When shareholders, when they want to wind up the company, so there's one thing that needs to be proved, right? There's one thing that needs to be proved by the director, which is something we call the statutory declaration of solvency. What I mean by solvency? So it means that the company is capable to repay all the debt within the coming year. Okay, I'm a member. I pass the resolutions. I want to wind this company, so I can do so, right? I can do so. But there's one thing that need to be, right? That need to be confirmed by the directors. The company here is solvent. The company is capable to pay all the debts within the coming 12 months. So if you are capable to do so, then you can initiate voluntary winding up. Up to you. You can take care of your own things because you are not, having debt to the outsiders. But if you are not capable to do so, right? If you fail to do so, then the winding up cannot be handled by if the members want to wind the company, and the director can produce statement of solvency. It means the company is solvent. Then go ahead, right? You can manage your own things. You can wind your company. But if the director cannot produce the certificate of solvency, it means the company is actually insolvent. Well, do you understand what I mean by insolvent? 資不抵債. It means the company is not capable to pay all the debt. The debt is over the asset, right? The debt is over the asset. So the company cannot pay, unable to pay. Then that thing turns into creditor voluntary winding up. Do you understand here? Right? So that's very important. Maybe you don't understand everything, but at least I hope that you understand. Number one, compulsory winding up means a court proceeding. You try to wind a company under court order. Voluntary winding up, it means that you try to use the company's own mechanism to wind the company. You are not relying on the outsider. So the director can do it. The members can do it. But no matter for the directors or for the members, you have to make sure that the company is solvent, right? Solvent. Asset over the debt. Then you can do so. You just do it. you can do it. Feel free to do it, because you are not creating trouble for the outsiders. But if your company not capable to pay all the debt, 資不抵債, so that action turn into creditor voluntary winding up. Because the creditor, they have to take charge of everything. If your company is insolvent, think of it, right? You hurt the creditors. So that must be managed by the creditors, okay? And one more thing, remember that liquidators, winding up is all about liquidator. So all about this person. So this person being appointed maybe by the court, or by the director, or by the shareholders, or by the creditors. That's all about liquidators. And all about who appoint that liquidators. Because no matter who appoint that liquidator, the liquidator do one thing in winding up. Handle all the assets, sell all the assets, and then to satisfy all the claims. Liquidator always do the same thing. So the problem is that who appoint that liquidator, and who can still control that liquidator. So that's the key problem between different ways of winding up. All right. One more thing before we end the vision class series. So regarding winding up, so one thing we always need to bear in mind, we have to think about the priority of claims. So if the company is solvent, if the company is capable to settle all the debt, the company is in debt 1 million, but the company is having 3 million assets, then we don't have to think about priority, because everyone will be happy. We have more than enough money to satisfy all the claims, okay? But if the asset is not enough to satisfy all the claims, then we have to make a decision. Who get it first, right? Who get it first? Then we have to follow the priority here. So I already list out. So fixed charge being number 1, but fixed charge is actually over number 1. The fixed charge, something already belongs to that person, even over than the first priority. Then follow with the remuneration of the liquidators, prevention debt, foreign charge, and security creditors, and then at the end, shareholders. All right? Okay, I think that's the end of the vision class. If you have any questions here about the exam or anything, you stay here, and we can